JP, thanks again for talking to Anchored in Law.
Thank you very much, Mr. Ngalwana. Thank you.
The unembedded take on law, as we say. Now, can we move on to your judicial philosophy? There is an old judge of the Supreme Court of Appeal, not Supreme Court of Appeal, the Supreme Court in the United States, Oliver Wendell Holmes, you must have heard of him,
Yes.
who is reputed to have said, young man, a court of law is not a court of justice, it is a court of law. Do you subscribe to that philosophy?
Thank you, Judge, for that question. Firstly, my philosophy in law, I'm guided by the Constitution. That for me is the anchor, it is the compass, it is the most important source of the rights which are contained in the Constitution and the Bill of Rights. That's what informs me, because the Constitution is a product of a long struggle, especially on the part of the black people, struggle for liberation and recognition as people in this country. As to whether or not I certainly do not subscribe to Oliver Wendell Holmes' philosophy. For me, justice and equity and law cannot be separated. Where the laws are unjust, for instance, in this country, before 1994, we had no right to vote as black people. Only whites had franchise. In my view, I have made this public, that legal system was illegitimate. Illegitimate because the vast majority of the citizens of this country were not represented. But obviously to those who benefited from the system, there was justice. But for me, apartheid laws lacked justice because they were not founded on democracy. You had at least 80% of the population being excluded. Therefore, there was no justice. You can't say there was a perfect legal system. For me, you can't separate justice, equity from law. Any legal system which does not ensure that justice is there is doomed. After all, law is about regulating human behavior. So you cannot ignore the rights of individuals and claim to have a legitimate system. That explains in part why apartheid collapsed, because it lacked legitimacy to begin with.
Okay.
Irrespective of what the oppressors said in those days, there was no legitimacy in the legal system. So I don't subscribe to that. For me, you can't separate justice from equity and from any other legal system.
Let's segue into that answer with this question. Judicial activism, because we still have remnants of apartheid laws existing. Like, I think the Riotous Assemblies Act is still
in the statute
place.
That's right.
One of the opposition leaders, I think, was prosecuted under it. I think the EFF leader, if I'm not mistaken.
It was indeed Julius Malema.
Yes. Now, I'm not sure where that case ended, so I haven't been keeping tabs on it. Now, would you, perhaps let me phrase the question this way. What is your understanding of what judicial activism is? And after you've answered that question, would you consider yourself an activist judge?
Right. For me, there are two extremes. You have what we call judicial activism and judicial restraint.
Yes.
Judicial restraint occurs where a judge prefers to defer, for instance, to the executive or to parliament, even in instances where there is no reason to do so. Remember, I come from the school of thought which says a completely unambiguous statute is yet to be enacted. So there is always room for judicial activism as opposed to restraint. Of course, judicial activism is when a judge is prepared to push the envelope in order to get the best results in any given case. In other words, the judge does not feel that he or she should defer to parliament in any given case or defer to the executive. But the judge, in the exercise of his or her powers, relies on the Constitution and the law of the land and applies that to a given situation or extend those principles to an area that is completely new, that was not thought of. Right?
Well, when you say, sorry to interrupt, I'm not, have you finished answering that?
I wanted to say, your second part of your question, I regard myself as a judicial activist.
Mm.
I have not hesitated in many, many instances to fill the gap. A very good example, I sat in a matter, Alves versus the Law Legal Practice Council. The facts briefly there, the Legal Practice Council was opposed to the admission of attorneys and advocates who wanted to convert from the attorney's profession to the advocate's profession and vice versa. I ruled that we were two judges. I wrote the judgment. I ruled that let us use the purposive interpretation. What was the intention of the Parliament? Parliament did not intend that practitioners who are advocates should not be able to leave the advocate's profession and join the attorney's profession. You cannot say, I ruled in that judgment, you cannot say people who are new to the profession must be preferred over and above those who have already been in the profession. Right? So that to me was a clear example of wanting to take existing principles of the law, you extend it by saying, what did Parliament have in mind in doing this?
Yes.
Another example was in Kiza versus Bata, a case which concerned African customary law. What had happened in that case, the parties lived together as husband and wife, and the husband, after 12 years of being married to this particular lady, refused to pay maintenance, and when she insisted on maintenance, he said, what are you talking about? We are not married. Because some of the requirements, umegeda, as Abaswazi call it, one of the requirements for a valid African customary marriage according to Swazi custom was not met. I took the view that if there is a valid requirement which has not been met, but everything else has been met, look at the intention of the parties. You cannot live with a woman and you father 3 children. You say when she sues you for maintenance, what are you talking about? I'm not legally married to you. That to me is a good example where you're an activist. You would want the principles of law which exist to cover other areas of law.
Let's clarify something. You said when you were first answering this question about judicial activism that, I'm paraphrasing, you need to make a decision regarding the intention of Parliament and not necessarily defer to Parliament.
That's right.
Now, lay people may criticize that and say, well, you're running the risk of overreaching and doing and trespassing into the terrain of Parliament, which is to make laws. Yours is simply to apply the law and develop the common law, as it were, in terms of Section 39(2), I think, of the Constitution. So you are not saying that by not deferring to Parliament, you are free as a judge to usurp the functions of Parliament.
Yes, I'm not saying that.
You're not saying that.
There's a very thin line between being an activist and usurping the proper functions of Parliament, which is to make the law. But where I come from, a completely unambiguous statute is yet to be enacted. And secondly, a judge is not a mathematical symbol. When you interpret the law, you are guided by the values that are in the Constitution. Then you say to yourself, what did Parliament mean or intend here? You interpret that against the Constitution. Clearly, in a situation whereby it is the legislative function to perform something or to enact the law, you would defer to Parliament and say, there is no law which says that. I mean, we can multiply examples. For instance, in the South African context, the possession of cannabis has been decriminalized, but it has not been legalized. There is a difference between decriminalizing it and say you may lawfully possess it for your own use, as I understand the law, right? But it has not been legalized. I think it would be wrong for any judge to legalize it because Parliament stopped short of legalizing it. All that Parliament has done is to decriminalize it. So there is a very thin line between being an activist, and I regard myself as a judicial activist, and usurping the powers of Parliament. Where you usurp the powers, you are acting improperly, you are overreaching, because in a situation like that, we've got to be careful. We are not elected.
Yes.
We are appointed as judges. Where appropriate, defer to those who have been elected properly, because
Right.
we live in a democracy.
All right. Thank you, JP. In the next segment, I'd like us to go into the Chief Justice position. You've been nominated as a candidate running for the position of the next Chief Justice.
Yes,
I'd like us to deal with that topic in the
by
next
all
segment.
means. By all
Thank you.
means, thank you.